Hi, everybody. Welcome to Webinar Wednesday. I am Jonah. I'm the director of the Land Use Education Program, which of course is run out of Virginia Tech, and it's a partnership between Virginia Cooperative Extension and Virginia Tech Center for Public Administration and Policy. Today we're going to be joined by Jesse Richardson. He is the lead land use attorney for the Land Use and Sustainable Development Law Clinic at West Virginia University in their College of Law. He is associate professor, or used to be an associate professor at Virginia Tech, and is currently one of the board of directors for the American Law Association. So Jesse comes to us by way of Virginia Tech, but now is with WVU, and he and I have been arguing for better or worse since 2008 when we met. And one of my favorite memories of Jesse is when we were both attending a land use workshop, probably 2009 or something like that. And we were sitting in the back arguing about some kind of land use law stuff, and the host from the workshop came up to us and tried to shush us. So that's typical of our relationship, I think, Jesse.
Mm-hmm.
Yeah. All right. So a few housekeeping points before we get to Jesse's presentation. I just wanted to remind everybody that today's presentation is going to be up on YouTube after the presentation. I simply have to hit one button, as I understand it, and the presentation will immediately be available via YouTube at the link that you joined us at today. Aside from that, if you're on this broadcast, you are probably able to see the chat box just to the right of the broadcast, and that is where you'll be able to post questions for Jesse. He's able to see what it is that you're writing, but the only two people who are able to speak out of the broadcast are Jesse and myself. So if you want to yell at Jesse, he won't be able to hear you, but maybe in future broadcasts we'll be able to fix that concern. I'm going to do about maybe 40 minutes of a presentation, Jesse.
Okay.
Okay, and then we'll do some question and answer at the end. He and I can kind of go back and forth and try to address your concerns, questions, and outrages. There's also a link in that chat box, or maybe it's this direction, that you can fill out the evaluation for the webinar. It really would be helpful if you guys can take a look at that evaluation form, provide some feedback to us, so as we go along and try to provide more of these Webinar Wednesdays, we can be effective and improve what it is that we do. All right, enough about this housekeeping stuff. Jesse, you have gone around and around on land use law conversations over the years. Signed ordinances are no different. I know there was a Supreme Court decision last year that really affected sort of how the state can control free speech and what it considers allowable speech and doesn't want to allow, which is sort of broad reaching. It certainly came out of a land use law case with regard to signage, but has spilled over into areas of license plates and other kinds of state-sponsored speech. I know you'll be getting into lots of these issues of state-sponsored speech and freedom of speech, constitutional issues, and where all this kind of came from and why it's such a mire and confusing, I think, for local administrators to deal with as an issue. So without further ado, I'm going to turn it over to you. I know you've got a PowerPoint, but you may also want to provide some kind of introduction for yourself. So Jesse, take it away.
Okay, yeah, we are going to try to look at some of these sign issues. I'm actually going to try to keep it pretty simple because if I tried to do everything that Jonah was talking about, we'd be here for several weeks probably, and I should go back. So I'm going to focus on the recent U.S. Supreme Court decision and what that may or may not mean for sign ordinances at the local level. Excuse me. I do want to give a shout out to the two planners at the WVU Land Use and Sustainable Development Law Clinic, Christy DeMuth and Jared Anderson. They're both on the webinar, so I'm sure that they will be arguing with me and harassing me afterwards, as they do every day. Jared is also an attorney, and we're working on a lot of these issues here in West Virginia. Couldn't do a sign ordinance webinar without talking about the famous song that talks about signs, and so I just had to put that in there. So what is a sign ordinance? A sign ordinance it regulates the size, height, location, or other aesthetics of a sign. And we have to balance the needs of the public versus the needs of businesses. In many cases, sometimes it's going to be individuals and a wide variety of people. Really, at this point, there is no ideal model for sign regulation. All communities are different, of course, and this is no different. Also, I understand that the International Municipal Lawyers Association had a model sign ordinance, but after the U.S. Supreme Court decision came out, they felt like that their model sign ordinance would probably not pass muster. So like a lot of things, sign ordinances may be part art and part science. Why do we regulate signs? Clutter is really a big problem for a lot of communities, especially their commercial corridors. Safety for drivers and pedestrians is often cited, and aesthetics is often cited. But the law is really clear that free speech can be limited to protect the public good or to protect public safety. However, we have to walk that tightrope between both of those things. So how do we regulate signs? 3 different ways. You can regulate it under health, safety, welfare, and morals, the police power. Some communities have standalone sign ordinances. However, I would say that that standalone ordinance, it quacks like a zoning ordinance, it waddles like a zoning ordinance, it's probably a zoning ordinance, but we put it in a separate chapter or the like. And then sometimes the sign ordinance is included with your zoning ordinance. And the challenge is definitely trying to balance free speech with community regulation. So at this point, I am going to get into the U.S. Supreme Court decision that caused a lot of waves. It was released in June of 2015, and it involved the Good News Presbyterian Church. And the church was putting out temporary signs to direct people to where their worship would be on that particular day. They didn't have a permanent building, so they had to put signs out each week to tell people where they could come for that particular week. So the real question in the town of Gilbert case is, did they regulate content? And to tell you a little bit about their ordinance, it prohibited the display of outdoor signs without a permit. However, there were 23 categories of exemptions from that requirement. One of those categories was a temporary directional sign, and that's the part of the ordinance that the church came under. And the ordinance said you can have no more than 4 of these signs. They were limited to 6 square feet each, may be on a single property at any time, and no more than 12 hours before and 1 after the event. Now, 2 other categories that were part of this argument was political signs and ideological signs. And the restrictions on political signs and ideological signs were more permissive than the restrictions on these temporary directional signs. And so the U.S. District Court said this is not content-based because we're looking at, we're not looking at a community that's trying to suppress certain ideas. We're really looking at a community that's trying to regulate fairly. The Ninth Circuit Court of Appeals affirmed that and said, no, these are not situations where the government is trying to suppress certain ideas of a nature that they disagree with. So it's not content-based. The importance of whether it's content-based or not is that if it's content-based, we apply a strict scrutiny test. And basically, if the court applies a strict scrutiny test, the government loses. It's very difficult to win under that test. If it's not content-based, then the court will likely apply intermediate scrutiny, much easier for the government to prevail in that context. So what did the U.S. Supreme Court say? They said this is a content-based regulation, and therefore it is subject to strict scrutiny and cannot violate the First Amendment.
Hey, Jesse?
Yes.
Jonah, I just wanted to make sure, if you are trying to share PowerPoint slides, we're not able to see that right now.
You are not seeing any slides, huh?
You just need to make sure you do the screen share.
I'm sorry, I thought I had got that. Okay.
There you go. Looking good.
Sorry about that, everybody. You didn't get to see all my brilliant PowerPoint slides.
You're in good shape now.
All right. So the court did hold that it was content-based and cannot violate the First Amendment. So now that you can see my slides, I'm going to go to some of my really ugly slides that you really don't need to see anyway. This was essentially a 9-0 decision, which is a little surprising for me that there was so much controversy about a decision that was 9-0. However, to get a little deeper, it was 9-0 that the sign ordinance was unconstitutional. However, 3 of the justices, Justice Kagan, Justice Ginsburg, and Justice Breyer, filed a concurring opinion that while it agreed with the result, it disagreed that strict scrutiny should have been applied. And I'll talk about that in a few minutes. So it's essentially a 9-0 decision. And when I talk about the concurring opinion by Kagan, Ginsburg, and Breyer, you'll see that the concurring opinion did no favors for sign ordinances or for the town in this case. So the court said this is content-based. And how do we know whether it's content-based or not? The court said it's content-based because I have to look at what the sign says to determine what the rules are. And if that's the case, then it's content-based. And the court said, you've misunderstood our opinions. It doesn't really matter if the regulation is based on disagreement with the message, and it doesn't matter that no particular idea or viewpoint is mentioned or singled out for differential treatment. All that matters is whether it is content-based or not. And the town had argued that it relied on the identity of the speaker. The court said, well, not really, because it doesn't matter who would have put out these directional signs. They're subject to the same rules. And even if it did rely on a speaker, it doesn't matter because the ordinance is still content-based. And now, as Jonah said, I usually have opinions about everything, and not everybody agrees with my opinion, especially Christy at the office. But in my opinion, this makes a lot of sense. And if you want to read, if you've got some psychological problems and you want to read the court opinion, you can find that on the internet and read some of the rationale of the justices. But they basically said that trying to suppress any type of speech is what we're going to address. We're not going to look at the motives. We're not going to look at whether a particular idea or viewpoint is singled out. We just want to make sure that speech is free and that we're not going to distinguish types of speech based on what is the content of the speech. So because the court said it's content-based, that means strict scrutiny applies. And here's the test. The government must prove that the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. And the government almost always loses under this standard. The justification that the town put forth to meet this standard were preserving the town's aesthetic appeal and for traffic safety. And again, this last quote that I have on this slide that the majority put out, I agree with that, that if anything, a sharply worded ideological sign is probably more likely to distract the driver than a sign directing the public to a nearby church meeting. To me, that makes sense, that it doesn't matter what the content is, it matters how big is the sign, what are the colors, does it have neon lights, is it going to distract people? That's really the key when we're looking at this. If intermediate scrutiny would have applied, it's not a whole lot different, but it's a substantial government interest. And it again has to be narrowly tailored, and it has to leave open ample alternative channels of communication. And the court has said that promoting the locality's physical appearance and the reduction of distractions, obstructions, and hazards to pedestrian and auto traffic are substantial government interests. We'll learn in a few minutes that maybe it doesn't matter in this case what test the court applied. So Kagan, Ginsburg, and Breyer, who concurred in the final decision but said we should not apply strict scrutiny here. And they made some type of statements to the extent that, we're really, do we need to pull out strict scrutiny for all these types of things? And they painted a pretty negative picture. They said now communities will have to either repeal the exemptions that allow for helpful signs on streets and sidewalks, or they're going to have to lift the sign restrictions or lift them all together and resign themselves to the resulting clutter. So that's not a very pretty picture. In their opinion, strict scrutiny should only be applied where there is some realistic possibility that official suppression of ideas is afoot. Again, I'm going to interject my opinion on that. My opinion, if courts were to try to decide when is there a realistic possibility that official suppression of ideas is afoot, how in the world do we know that? So whether you like the decision here or don't like it, one thing that I think you have to admit is that it's easier to apply the majority opinion in this case than it would be to apply the concurring opinions test of we're going to apply strict scrutiny only when there's a realistic possibility that official suppression of ideas is afoot. Only 3 justices agreed with that, so that's not the law as of June of 2015. However, Kagan goes on to say, and this I think is the nail in the coffin for a lot of existing sign ordinances. Kagan says, regardless, Gilbert's sign ordinance would not pass strict scrutiny, it would not pass intermediate scrutiny, and it would even not pass the laugh test. Ouch. This is a type of ordinance that a lot of communities have, and according to the US Supreme Court, it would not even pass the laugh test. So that's pretty clear that even though there might have been some disagreement, this particular ordinance, it's not going to survive in any case. So now I'm going to start talking about what I think is the more important issue. What can local governments do after Gilbert, or what should they do? Obviously, local governments are going to have to look at their existing sign regulations to see whether they are content neutral. And we are doing this at the clinic. We have some students that have looked at this issue, some law students, and we have started to get communities that are saying, is the sign regulation that we have, is it constitutional? Are there categories of signs singled out on the basis of the message? And I think in light of Gilbert, particularly look at time constraints that they place on the signage. This was a very sympathetic plaintiff here, a church that was just trying to direct people to their weekly church meetings. So you have to regulate with that in mind. Now, the court did provide some guidance on what communities can do after Gilbert. First of all, the majority opinion, pretty straightforward. They said local governments can still regulate the size of signs, the building materials on signs, the lighting, the moving parts of signs, and the portability of signs. I think the message that the court is giving is that a sign is a sign is a sign, regardless of what it actually says. If a particular sign is going to distract motorists, or if it's going to detract from the beauty of a community, it doesn't matter if that sign says, vote for Jesse Richardson, or whether that sign says that the church service will be down the road on Sunday. What matters is, what does the sign look like, how distracting is it, and not what it says. With respect to public property, the court said that the local government can go a long way towards forbidding the posting of signs, as long as it does so in an even-handed, content-neutral manner. So on public property, lots of leeway. On private property, much less leeway. The concurring opinion of Alito, Kennedy, and Sotomayor, and those are 3 justices that joined the majority, it gives more guidance, or at least more detailed guidance, and says that you can regulate lighted signs versus unlighted signs, fixed messages versus electronic signs with changing messages, placement of signs on private property versus public property, placement of signs on commercial property versus residential property, whether a business places a sign on premises or off premises, that can make a difference, and you can regulate that. You can regulate the total number of signs per mile of roadway. You can put time restrictions on signs advertising a one-time event, and you can put restrictions on governmental signs. So these three justices that were part of the majority, they paint a much brighter picture of the future of sign ordinances. And they say, as long as you properly understand today's decision, it will not prevent cities from regulating signs in a way that fully protects public safety and serves legitimate aesthetic objectives. And that is about all the justices tell us in the Gilbert case. That's all the guidance that we have in that case. At this point, I want to move on to a couple of Virginia cases and talk about commercial speech a little bit and probably confuse people even more. But first of all, commercial speech is a little different. The government can regulate that. The commercial speech must be of a lawful activity. The government must have a substantial interest to regulate it. The regulation must advance the asserted government interest, and it must not be more extensive than necessary to serve that interest. Now, I put out that test and I talk about commercial speech, and I have to admit, I don't know how the Gilbert case is going to affect this. And I'll talk a little bit more about that. But the U.S. Supreme Court mentioned commercial speech in the Gilbert case, but didn't really dwell on it much, so I don't think we know what's going to happen. Two cases from Virginia, one that is over, one that is still proceeding, I think could tell us a lot more. Wagmore dogs, that is from Arlington County, Virginia. Lots of sign cases from Virginia for some reason. And in that case, a owner of a canine daycare boarding and grooming facility put up what they called a mural. And the local government allowed murals, and they were much more liberal with murals, but it prohibited signs of that size. This mural, and you can see part of it here on the PowerPoint slide, contained it contained the symbol for the business, contained images that really promoted that business. And so Arlington County said, no, this is a sign, you have to take it down. And the owner basically said, well, wait a minute, this is a mural, it's not a sign. And the local government said, but the images on the mural promote your business, so it's really a sign. And the Fourth Circuit Court of Appeals said that the ordinance in that case was content neutral. It satisfied intermediate scrutiny and did not violate the First Amendment. It was not unconstitutionally vague, and it was not an unlawful prior restraint on speech. So the owner of Wagmore Dogs had to cover up the mural / sign. I don't believe that case was appealed to the United States Supreme Court. I'm almost certain it was not. The next case is pending, and I think could have a huge impact on sign regulation. So the Central Radio versus City of Norfolk case, and I don't know if we have anybody from Norfolk on the call or on the webinar. If we do, whatever I say is just the musings of an academic and not intended to be legal advice. But in that case, the lower court and the Fourth Circuit Court of Appeals upheld the Norfolk sign ordinance. And this ordinance allowed flags of any nation and several other types of displays to be made regardless. And there were some limitations on that, but not a whole lot. However, signs were more restricted. And this is the sign that Central Radio put up. Central Radio was subject to an eminent domain proceeding by the city to acquire land to expand Old Dominion University. And so to express their discontent, Central Radio put up this sign and said that we should get rid of eminent domain abuse. I think to try to fall into the exception in the ordinance, they put an American flag on it to say, oh, we're exempt. The Fourth Circuit said that the sign ordinance was content neutral. The ordinance furthered the city's substantial interest in aesthetics and traffic safety, and it was narrowly tailored. The owner of the business did not offer any evidence of improper motive in enforcement or significant departures from normal procedures in enforcement. So they had alleged that there was abusive enforcement in this case, but they never presented any evidence. And the ordinance also had a certificate requirement that you had to get a certificate. They said that was not a prior restraint of speech. So why do I care about this case so much? Why I care is that the United States Supreme Court did something a little strange or a little unusual. Prior to deciding the Gilbert case, the United States Supreme Court accepted, or they agreed that they would review this case. So they said, okay, we're going to accept this case for review in the United States Supreme Court. However, after they decided the Gilbert case, without comment, they sent the Central Radio case back to the Fourth Circuit Court of Appeals and said, look at this again in light of the Gilbert case. That's something pretty unusual for the United States Supreme Court to do. In reading the Central Radio case and in reading the Gilbert case, in my opinion, and this is my opinion coming up here, I think the court is sending a not so subtle message to the city of Norfolk and to the Fourth Circuit that this sign ordinance is indeed content-based. Interestingly enough, the dissenting opinion in the Fourth Circuit Court of Appeals in the Central Radio case, the dissenting judge said, I would apply a content-based test to the city's sign ordinance. As the majority opinion recognizes, this court's so-called practical inquiry is meant to determine if the government's regulation is justified without reference to the content of the regulated speech. As the Fourth Circuit said earlier, lack of a relationship between a content distinction and its legislative end is meaningful to determine whether they've discriminated. However, this justice disagreed that the city demonstrated a reasonable fit between the city's interest in aesthetic and traffic safety and the exemptions for government and religious emblems and flags. And I think it's interesting next what the judge says is that why is it that symbols and text of a government flag do not affect aesthetics or traffic safety and therefore are not regulated, whereas a picture of a flag does negatively affect those interests and must be subjected to size and location restrictions? I see no reason in such a distinction. So even though the dissenting justice looked at it a little differently than the U.S. Supreme Court, it came down to the same problem that the U.S. Supreme Court had. Why does a flag whipping in the wind distract drivers less than a big sign with a flag on it? Why does a flag not impact the aesthetics of a community as much as a sign with a flag on it? They didn't see the distinction, and I think that's important. So to start to wrap up, there is more than one way to draft a sign ordinance, but the U.S. Supreme Court has supplied some guidelines that I think all local governments are going to have to comply with. And whether, I think, here are some questions that I think are going to come up. And I've already talked about this with some of the people in the webinar, is I know a lot of communities like to have public art and things of that nature. Well, why is a piece of public art on a building, a mural or the like, doesn't that distract drivers as much as a sign, or maybe more? And so whether we like it or not, I think we're going to have to look at any type of public display that distracts drivers or can be seen by the public or affects community aesthetics. I think we're going to have to look at those under one type of rubric. And it kind of, when I lived in Blacksburg, they passed an ordinance basically to keep Walmart out of Blacksburg. And they had a minimum square footage. Anything above that, special rules were going to apply. So I pointed out to the town that Kroger has more square feet than your ordinance says. So Kroger falls under that rule as well. What I heard was, but we like Kroger. And I think the answer that the U.S. Supreme Court would say is the same one that I said. I don't care whether you like Kroger better than Walmart. You have to apply equal rules to them. For just a minute, I want to show some of the funnier signs that I've become aware of. Church parking only, violators will be baptized. I like this one. What coffee do Beyonce be drinking? All the single lattes. And then these are just some horror stories for signs, I think. And now we have time for some questions.
All right, so thank you, Jesse, for that presentation. I think that gets at sort of the heart of the decision from 2015 especially, but also gets into some of the vagaries of sign ordinance law. I think we've got one question from the chat box that I can see. If other folks have some questions, I'd ask that you, this process basically at this point is you need to sign into Google with whatever email address you have available to you. And then you can head back to that chat box and type in your questions for Jesse. You can see them, but I'm happy to have a conversation with Jesse about some of these points as well. Jesse, clearly you have a great understanding of sign ordinance law, and I think some people struggle to just keep up with what is allowable and what's not allowable, myself included. The great point that you made about sort of the nature of aesthetics, it is very hard to put your finger on, especially these case examples of a flag versus an image of a flag, or a mural versus a sign, and it gets into whether or not the government is regulating for one of its stated powers, so health, safety, and welfare of the public. Is there anything that we can look to aside from case law that really kind of puts into focus what aesthetics is, or what is allowable by the government to consider under the aesthetics guidelines?
That's a good question, Jonah. And in general, aesthetics is a really tough one, because the court has talked about aesthetics a few times. Even the United States Supreme Court has talked about aesthetics. And now I'm blanking out. It might have been Berman versus Parker, but in several cases, the court has said that certainly local governments have an interest in making sure that their cities are beautiful, and that type of thing, and they do. However, I think purposes come in a spectrum, and I would also compare it to land conservation. I think the court is going to say, if you are going to protect land, or if you are going to regulate land for the national security interest, you're going to have a lot more leeway than you are if you say, I want to protect land for aesthetics. If you say, I'm going to protect land for agriculture, I think that comes somewhere between national security and aesthetics. But I think aesthetics is important, but some cases have even said that you can't just rely on aesthetics alone. There has to be another reason. And so certainly you can look at aesthetics, but you're much better off if you add some purposes. I think the other danger too is that what is aesthetically pleasing to me may not be aesthetically pleasing to you. So it's important that you have clear standards that you can easily measure, and that they're not too vague, and that can be difficult.
Well, I think it gets into that, that Supreme Court case that we just had, where the locality has had, an ordinance on the books, and people are trying to follow the ordinance best they can, but still, that ultimately the applicant for the signage felt that there was maybe the government was kind of unevenly applying its own standard, sending the case to the Supreme Court ultimately. Mm-hmm. So it does appear that there is, a gray line about what is considered allowable, and it's really hard to put your finger on exactly, when you've crossed that line. For free speech issue, it does seem like there's a lot of regulation about, location, size, and all these other issues that come into it. So I don't, based on the presentation you've made, it doesn't sound like there's going to be sort of an end to this aesthetic argument. But connecting things back to a safety issue, mm-hmm. Visibly, being able to see a sign and its commercial interest, I think that there's a whole lot of those kind of questions that are aside from free speech. They do get at substantive issues. Looks like we have a question from Daniel Galvano. I'm aware that Virginia Local Government Attorneys Association is working on a model ordinance in response to Gilbert. Do you know of anything else that's going on out there, aside from Virginia perhaps, but other states that are working on model ordinances?
The only other one that I'm aware of is the International Municipal Lawyers Association is working on another model to replace their existing model. And I know that we have talked here at the clinic about trying to come up with a model. I don't know how far away that is, but those are the only ones that I'm aware of. We also had a couple of questions from Chris Bledsoe. And I think you're right, Chris. I think the bottom line is that you don't want to be subjected to strict scrutiny, so you need to make sure your ordinances are content neutral. As I'm not sure exactly what you mean by purpose neutral. I think the purpose of the ordinance, the purpose of sign ordinances that I've seen are pedestrian and traffic safety and aesthetics. And there might be some others, but whatever you put in the ordinance must promote traffic and pedestrian safety and aesthetics. So you can't say that I'm promoting traffic safety and aesthetics and I'm trying to think of a requirement that would have nothing to do with that. Every sign has to have a picture of Jesse Richardson on it. That has nothing to do, except it might negatively impact aesthetics. So anything you do in your ordinance has to promote the purpose that you're putting forth. And to me, another thing that I'd say, especially with planners that are on this, is that isn't that what we want to do with all our land use ordinances? That if our purpose is to have our streets be safe or have it be walkable, then we want the regulation to promote that. And so I think, again, that makes a lot of sense. And Chris had another question about the public art. And that's me, that's my spin on it. But I have talked to Mark Flynn with the Virginia Municipal League, and I know that Mark, I don't want to put words in Mark's mouth, but I know he was concerned about the impact of Gilbert on public art and whether we're going to have to look at it this way. And maybe not, but to me, it raises that issue. And I know in Blacksburg, those of you that are Hokies, we have those Hokie birds all over the place in Blacksburg. And I was in Norfolk for the Virginia APA, and they have those mermaids all over in Norfolk. And I wonder if that distracts people when they're driving and the like. And if that's the case, maybe they have to fall under the same regulation. I would put in an exemption for anything that's orange and maroon and relate it to Virginia Tech, but I don't think that would hold up.
Well, this is another question, because at what point does a standard get applied? I think you raised the point in the Central Radio case, where these flags had basically a claim that they'd been up for decades, and then somebody down the road had a problem with the sign, with the quote-unquote signage, raising the legal issue itself. Is there any kind of guidance for people who have existing signage and then find themselves in the crosshairs of an enforcement action? Is there anything that the localities need to be aware of in terms of changing their sign ordinances? I mean, this aesthetics question really does kind of draw fire, essentially.
Yeah, it really does. Well, I'll say a couple things on that. First of all, in the Norfolk case, the Fourth Circuit talked about the fact that Norfolk enforces their sign ordinance just like I think 99.9% of local governments enforce their ordinance. It's complaint-based. I don't know very many communities that have the resources to ride around and try to find violations of their ordinances. We rely on complaints to do that, and I don't think there's anything wrong with that. But that is, in that situation, you might have a sign that's been up for 20 years and nobody complained, But now somebody complains, and if the city goes out and finds a violation, you've got to take it down. So from a landowner's point of view, the fact that you've had the sign for a certain number of years or the like doesn't mean that you have a right to keep it there. If it violates the ordinance, it violates the ordinance. Now, if a community amends their sign ordinance in relation to the Gilbert case, and there's already an existing sign that that violates that new ordinance but complied with the old ordinance, then in my opinion, that would probably be a non-conforming sign and would be subject to the non-conforming structures limitations and perhaps non-conforming use depending on the situation. And then that's a tough one. But I think all local governments should look at their ordinances in light of Gilbert and make sure that they are not content-based, because if they are content-based, you will lose.
And I think that you've got a point there. I think the content issue needs to be clarified in the Gilbert case, and it's, one of many cases that led to Gilbert. So maybe stay tuned to see how things develop. Do we have any other questions coming out of the chat box? Looks like people are fairly quiet there. Well, if there aren't any other questions, no sense in holding Jesse. I know he's obviously not had lunch. Hopefully other people have and enjoyed their discussion here this afternoon. Thank you, Jesse. I really do appreciate you being with us today. I know it's sort of a cold morning there in West Virginia, and sort of a inclement weather problem last night. So for you to be here today is really appreciated. For those of you who are still on the webinar, you may have an interest in our having some continuing maintenance credits through AICP. If you're a professional planner, we've been working with the American Planning Association Virginia chapter to make sure that you guys have available to you some CM credits for these webinars. As I learn more about when those credits become available, I'll pass that information along to you. If you've registered for this webinar, I should be able to get in contact with you. The webinar itself is going to be available immediately after. I've hit the stop broadcast button. It's available as a YouTube video, so if you'd like to rebroadcast this and share it with other folks, you're more than welcome to do that. Again, please see at the top of the chat box a link to the webinar evaluation. Anything that you can share with us to help us improve these sessions would be greatly appreciated. With that, Jesse, thank you so much again. I really do appreciate your time, and hopefully we'll have occasion to do this again in the future.
Thank you, Jonah, and thanks to everybody who joined us today.
Take care, everybody. We'll see you next week with another Webinar Wednesday. Take care, and make sure you look at planvirginia.com for other upcoming programs. Thank you. Take care.